Now, I'm sorry, it seems certainly coming into the court that it's very warm. If there's anything we can do about it, I'm sure it will have already been done or will be done now. Ms. Ford.
Thank you, my lady. I was moving on to make submissions on Huawei and ZTE.
Yes.
And we say that the judge's reasoning is consistent with and derives support from what the Court of Justice said on Huawei and ZTE. It's important to recall that, as Mr. Justice Burse pointed out, and this court agreed on appeal, the decision of the Court of Justice is focused on the position at the outset of proceedings, rather than after the passage of time. And it's also focused on whether it's abusive, contrary to Article 102, to seek an injunction, rather than the more nuanced question of whether the court should withhold injunctive relief at a later stage. And in that respect, Huawei and ZTE is applying a more demanding test. And so if, as we submit is the case, seeking injunctive relief is clearly consistent with the principles in Huawei and ZTE, then in our submission there can be no justification for withholding injunctive relief at this later stage in the proceedings. The Court of Justice was very well aware of the importance of injunctions to SEP holders. And the court would have already seen that from the Advocate General's opinion in paragraph 61 to 62, which Ms. Dimitriou took you to yesterday. Those were the paragraphs where the Advocate General said that for a patent holder that right represents the essential means of asserting his intellectual property. You were also shown paragraph 44 of the Court of Justice's judgment. This is starting at page 663 in tab 17 of the authorities bundle, and that's the paragraph where the Court of Justice set out its understanding of the question that was being asked. And it was essentially asking what circumstances seeking an injunction is to be regarded as constitutional abuse, contrary to Article 102. Apple took a point in their skeleton at paragraph 65 that the circumstances in Huawei and ZTE do not comprise an exhaustive list of when seeking injunctive relief by a SEP holder may be abusive. But in my submission, you can see from looking at paragraph 44 that this was the precise question that the referring court was asking and that the Court of Justice was answering. So it's very clearly on point for that purpose. Paragraph 46, you see the Court of Justice echoing what was said by the Advocate General about the right to bring an action for infringement being part of the rights the proprietor of an intellectual property right. And as Ms. Dimitriou showed you, you then see the court identifying two circumstances which distinguish the previous case law on intellectual property, namely that the patent is essential and the fact that the SEP owner is given a FRAND undertaking. Paragraph 52, I don't think you were shown this. This is the paragraph in which the Court of Justice articulates the competition concern that the Court of Justice perceives arises in this case. And it says, although the proprietor of the essential patent at issue has the right to bring an action for a prohibitory injunction or the recall of products, the fact that that patent has obtained SEP status means that its proprietor can prevent products manufactured by competitors from appearing or remaining on the market, and thereby reserve to itself the manufacture of the products in question. So in my submission, the competition vice that the Court of Justice is identifying is the risk that implementers will be excluded from the market. And it then goes on to articulate the nature of the abuse that it's concerned about at paragraph 53. And it says, a refusal by the proprietor of the SEP to grant a licence on those terms, by those terms it's saying FRAND terms, may in principle constitute an abuse within the meaning of Article 102. So the particular abuse that the Court of Justice is identifying is the refusal to licence on FRAND terms. And it goes on to say at 54, it follows that having regard to the legitimate expectations created, the abusive nature of such a refusal to licence on FRAND terms, may in principle be raised in defence to actions for a prohibitory injunction or the recall of products. However, under Article 102, the proprietor of the patent is obliged only to grant a licence on FRAND terms. That is essentially what the SEP holder must do to avoid being found to be abusive. Its obligation is to grant a licence on FRAND terms. And then the final sentence in 54 identifies the practical problem that arises. and that is the parties are not in agreement as to what is required by FRAND terms in the circumstances of this case. And that is the nub of the problem that the Court of Justice is grappling with. All the proprietor is obliged to do is grant a FRAND licence, but the parties are in dispute about what is FRAND, and that dispute hasn't yet been determined. So we then come to 55, and here the Court of Justice is telling the SEP owner what it needs to do in order to prevent an action for a prohibitory injunction or the recall of products from being regarded as abusive. And in doing so, it emphasises again the need to strike a fair balance between the interests concerned. And it's in that context that the Court of Justice then goes on to delineate a safe harbour whereby the SEP holder can take steps to seek injunctive relief even before the court has resolved the dispute as to what is FRAND without facing allegations of abuse of a dominant position. And that's what it's then doing in paragraphs 59 to 69, which you've already been shown. So this is a judgment which is sympathetic to the SEP holder and it's interested in enforcing its patents. And it's offering a way through the practical difficulties that arise from the fact that the FRAND terms of the judgment the SEP holder has to offer haven't yet been determined. Apple made the submission yesterday that the Advocate General and the Court of Justice are clearly contemplating that a licence might be negotiated ex post. And they make the point, well, this judgment doesn't say there's been an infringement, you need a licence now, and the way to achieve that is to give this commitment to call for a licence and take it. And it's true that the Court of Justice does contemplate that there might be scenarios where there will be no injunction, notwithstanding that there is not yet a licence. And that is for very practical reasons. One of those reasons is the one that comes through from paragraph 62 in this judgment. And it's cross-referring to point 81 of the Advocate General's opinion, which was a paragraph that most Dimitri referred to. And he makes the point, in view of the Court of Justice referring to the Advocate General makes the point, in the view of a large number of SEPs composing a standard, such as that at issue in the main proceedings, it is not certain that the infringer of one of those SEPs will necessarily be aware that it's using the teaching of a SEP that is both valid and essential to a standard. So the scenario being contemplated there is unwitting infringement. You don't actually realise. But of course, that is not this case. Here, there has been a finding of validity infringement, so you don't get this unwitting infringement possibility. The other scenario is the one that the Court of Justice recognised at 54, and you see it again at 68, where it refers to the possibility of determining FRAND terms by means of a third party, an independent third party. And that's the possibility that there might be a dispute as to the content of the FRAND terms. And the Court of Justice is concerned to ensure that a willing licensee won't be excluded from the market in those circumstances. But that, in my submission, is the important bit, because the party that merits protection in that scenario is the willing licensee. The Court of Justice is certainly not endorsing a scenario where an injunction is to be withheld in circumstances where the licensee is able to invoke the obligation to grant a FRAND licence but doesn't want to. The submission was made yesterday that the Huawei and ZTE steps, the steps that the Court of Justice is identifying, are required even when there is a finding of infringement. And the reason for that is that the purpose of these steps is to seek to ascertain whether the infringer is indeed a willing licensee or not. And when we come to see what the Commission says about this judgment as endorsed by the Supreme Court, we'll see that it's confirmed that that is what the Court of Justice is doing. So that's the purpose of the steps. Where the infringer has disclosed itself to be unwilling, Huawei and ZTE does not require an injunction to be withheld. You were shown yesterday what the Supreme Court has to say about Huawei and ZTE, and it's in Joint Authorities tab 16, starting at page 623. And this is the passage where the Supreme Court is citing and endorsing what is said by the European Commission. And it first of all, in the quoted passage, says, such relief aims to protect SEP holders against infringers unwilling to conclude a licence on FRAND terms. So pausing there, SEP holders need to be protected against unwilling licensees. The next sentence, at the same time, safeguards are needed against the risk that good faith technology users, threatened with an injunction, accepting licensing terms that are not FRAND or in the worst case are unable to market their products as hold-ups. In my submission, what is clear there is the party that merits protection is the willing licensee. You then get the passage where the Commission expresses its view as to what the Court of Justice was doing. And it says, in its Huawei judgment, the Court of Justice established obligations applying to both sides of a SEP licensing agreement when assessing whether the holder of SEP can seek an injunction against a potential licensee without being in breach of Article 102. SEP holders may not seek injunctions against users willing to enter into a licence on FRAND terms. Again, this is the notion you don't get an injunction against a willing licensee. And the Court of Justice established behavioural criteria to assess when a potential licensee can be considered willing to enter into such a licence. So that is what the Commission considers the Court of Justice is doing. It's setting out a means to assess whether the implementer is a willing licensee or not. In paragraph 157, we see that the Supreme Court agrees with the Commission's interpretation of what's going on. So just below letter G, it says, this coincides with the interpretation that we would adopt of the Court of Justice's decision. And it goes on to identify three things that the scheme set up by the Court of Justice is doing. And the first one is it prevents an organisation which is unwittingly using a SEP without a licence from being ambushed by injunction proceedings without any prior notification of the problem. That's the point I've already made submissions on, the circumstance where you don't know you're actually infringing. Secondly, it provides a route map, provides the SEP owner with a route map, which, if followed precisely, will ensure it can seek an injunction without risking infringing Article 102. That's the second point. And otherwise, it provides a number of points of reference to assist in assessing the all-important question of whether each of the parties is willing to enter into a licence on FRAND terms. So the third point is essentially an endorsement of the proposition that the purpose of the judgment is to try and assess whether or not each of the parties is willing. So we know that the Court of Justice was concerned to ensure that willing licensees were not excluded from the market, and we know that what it did was to set out points of reference to assist in assessing whether a licensee was indeed willing. And in those circumstances, clearly the judge was absolutely right to place emphasis in his paragraph 329(2) on the fact that Apple had the means to obtain a licence but had not taken them. In essence, it was not a willing licensee. And looking at the other side of the coin, the obligations on the SEP holder, we know that the potential abuse identified by the Court of Justice on the part of the SEP holder was the refusal to licence on FRAND terms. And in those circumstances, the judge was equally right to recognise as a key relevant factor the fact that Optis accepts it must give a licence and will obey the court's decision as to FRAND terms. That's the point he made in 329 little Roman 3. And so the abuse that the Court of Justice identifies, the refusal to licence on FRAND terms, is avoided. And the judge accepted a submission that was advanced below on behalf of Apple, that Huawei and ZTE showed that engaging in FRAND negotiation is important in itself. That's his judgment 78 and 128. But it's striking that you don't see the Court of Justice mandating the withholding of the injunction remedy on a blanket basis in order to deter abusive conduct in negotiations. On the contrary, what the Court of Justice did, as the Supreme Court found, was to provide a route map which, if followed precisely, will ensure it can seek an injunction without risking infringing Article 102. So, in our submission, the Court of Justice's reasoning in Huawei and ZTE is consistent with and supportive of the judge's reasoning in his judgment. My ladies, my lord, I make one final point, which is a practical point, and that is that if Apple's case advanced before this court were correct, it would mean that an implementer can avoid an injunction simply by pleading a potentially spurious but non-strikable competition law allegation of abuse of dominant position. And that is not a difficult thing to do, because allegations of abusive refusal to negotiate are fact-intensive allegations, and they wouldn't be susceptible to strikeout before trial. So it hardly needs to be emphasised that it would be a deeply undesirable state of affairs if an implementer could avoid an injunction in this way, and it would be a charter for holdout. And for those reasons, we respectfully ask the Court of Appeal to reject Apple's third ground of appeal. Unless I can assist further, those are my submissions.
Thank you very much indeed, Ms Ford. I think we come back to Mr Marge. Are you going to
Yes, if that's
change
all right,
places again? And this is ground 4.
Yes, I'm ready. I'm going to address first, if I may, the headline reasons why Apple's ground 4 should fail, and then I'll look at some of the specific points made in Apple's skeleton. Excuse me. Optis' pleaded case in the particulars of claim contained clearly a pleading for a unqualified injunction, paragraph 5, and a FRAND injunction, paragraph 5a. So at all times in this case, it's been clear what the form of any FRAND injunction would be. However, it is right that Optis did not seek that 5a form of injunctive relief at the trial F, excuse me. It was only sought in trial E, and I will just show you that because I want to make sure that that's absolutely clear. That is at Core Tab 19. This is the original list of issues for determination at trial F. There was a subsequent, more detailed one, but it doesn't matter for my purposes. It's page 227, and it's paragraph 1a, which makes it clear that, at least in respect of trial F, the particular form of relief was the paragraph A one, not the paragraph 5 one, not the paragraph 5a one. What the judge held at trial was that the appropriate form of injunction was, in fact, the 5a form of injunction. And the reason he made that finding was because of his conclusion as to construction. So, although the more limited form of injunction was not positively sought by Optis in trial F, the judge, in my submission, was perfectly entitled, A, to come to his own conclusions on construction of the contract, a point which I don't believe Apple tried to challenge, and point B, he was entitled, given his construction, to decide what the appropriate form of any injunctive relief should be, pursuant to the Senior Courts Act, Section 37, which, as the court is clearly aware, says you can impose any terms and conditions that the court thinks fit when ordering injunctive relief. And Unwide Planet, excuse me, Unwide Planet is a good example of that. In that case, no one had pleaded the specific condition, the FRAND proviso in the injunction, excuse me. But the court came to the view that that was the appropriate thing to do. And in my submission, given that Apple is not challenging the court's right to come to his own construction on the Etsy undertaking, it follows...
Well, that's not quite right, is it? Because, of course, by their grounds 1 and 2, added E3 perhaps, but certainly at minimum by ground 1 and 2, they're saying the judge was wrong on construction. But as I understand it, by this stage of the case, we have to assume that Apple have lost on that, and therefore we proceed to consider ground 4 on the assumption that the judge was right on construction.
Yes, your lordship's absolutely right. I should have been more clear. The point on construction I'm envisaging is that grounds 1 and 2 don't succeed, and the court's construction is adopted by this court.
Yes.
But not just the construction on the general point, but also his finding on the permanence point. And what I mean by that is the court rejected Optis's case on the permanence issue that I showed you earlier.
Again, we have to assume that you don't succeed on your cross appeal.
Exactly. But if any of those things aren't the case, then this ground 4 doesn't arise. So I am working on that basis. I should have made that clear.
Yes.
In light of that, what Apple don't do is say, notwithstanding those points, procedurally the court was wrong or unfair to come to its own conclusion on the middle ground construction that he adopted. What they say is he shouldn't have ordered the Frand injunction that he said followed from it. So what I'm going to do is address what the judge in fact did, which was come to a conclusion he was entitled to come to on the middle ground construction, and then look at what he factored in when exercising his discretion.
I'm struggling to understand why you keep on talking about construction. Ground 4 is all about procedure. And the nub of the argument is that it said the judge was wrong to grant a Frand injunction in circumstances where it was not your client's case going into trial F that there should be a Frand injunction, even in the alternative. And therefore, it is said it was procedurally unfair for him to allow you to argue for that in closing submissions. At minimum, he should have required you to apply to amend. And if you had applied to amend, he should have refused it.
Yes, my lord. But the reason I'm highlighting this is one of the things that I'm going to come on to show you is the judge said that the nature of a Frand injunction was built into Apple's arguments on construction itself, and that's one of the findings that I'm going to be relying on. So perhaps if we can open the judgment, then I can make that point good. So if we could go to paragraph 358. So I'll show you that first, and then I'll go through the other paragraphs of the judgment. The point that the judge makes in paragraph 358 is the notion of a Frand injunction was embedded in Apple's own arguments. And the reason I'm flagging that is they were arguments that were addressed in the context of the construction debate. But in my submission, it's an important part of his analysis that Apple's own arguments raised the concept of Frand injunctive relief because of the criticisms they made of Optis's permanence construction argument. So the first point I make is that the judge was right to, in applying his discretion as to what form of relief he could order, factor in that Apple's own substantive analysis raised this concept, albeit implicitly. And the way that arose is because Apple positively said at trial one of the big problems with Optis's case was that the injunction would be unqualified. And indeed, they pointed explicitly to the remedies judgment in Unwired Planet as showing that what would flow is not an unqualified injunction, but a Frand injunction. So although they hadn't pleaded it explicitly, it was part and parcel of the substantive debate about the merits of Optis's permanence argument. And in my submission, that's an important part of the court's exercise of its discretion, and it affects procedural fairness. Because, of course, if the Frand injunction is implicitly built into Apple's case, then I ask, how could it be unfair procedurally for the court to come to the view that that's the right relief in the circumstances. So that was the first point I wanted to make on the exercise of the court's discretion. The second point I wanted to make is the court did factor in Apple's procedural complaints about the possibility of further evidence. Now you can see that from paragraph 359. The judge explicitly said here that he heard renewed arguments about potential evidence that would have been served, and he focuses quite rightly on Apple's case that it would serve more modelling evidence from The Economist. Now, I'm going to come on to deal with the suggestion of evidence about American cyanamide, but just focusing on The Economist evidence for the moment, the judge heard extensive argument about that in the transcript, and we've given references in our skeleton on that. And he was perfectly entitled to come to the view that overall it wouldn't have made a difference. Now, Apple's skeleton says he held that the evidence was of no value, but that's not actually what he says. He says, I've made clear elsewhere in the judgment, the Economist evidence could only ever have very modest role at most in interpreting clause 6.1. And if you recall this morning, I mentioned some references in the judgment where he explained that although the overall evidence was compelling in respect of the risk of holdout, the particular modelling by Professor Farrell had not been of significance in his view on construction. So in my submission, they made their points. They made them a number of times on the last 2 days of trial. In the transcript, you can see that. And there's no error of principle in the court's overall assessment that evidence would not have been material. Another point that I should highlight on that topic is the judge made a point a number of times at the trial that he couldn't understand how the evidence could take matters further forward in this sense, because evidence about the impact of a FRAND injunction could only ever be less problematic for an implementer as compared with evidence of an unqualified injunction. And I can give you the reference to where that is. That's page 862 of the trial transcript, which is at supplemental tab 21. So in my submission, the judge was perfectly placed to make that overall assessment, having heard the evidence at trial. And Apple...
And isn't he partly reinforcing that point by the second part of the sentence that you've just referred us to?
Yes, exactly.
I mean, he is making a slightly different... I mean, I appreciate he's making a slightly different point there, but it is linked to the argument you're making.
Yes, there are sort of two elements to it, my lady, in my submission. One is, overall, the modelling wasn't particularly useful, and I've given you the references to where in the judgment he made that point generally about Professor Farrell's modelling. And the second point is, in any event, given the nature of the point that would have been addressed, it wouldn't have had a change to the overall analysis in a material way. In my submission, it can't be said that the judge has come to a conclusion that's so outside the normal course that first instance judge can take, that there's some kind of error there. The second point that my learned friend developed more orally was the suggestion not so much about modelling of the Economist evidence, but an argument that Apple may have wanted to put some evidence forward of an American cyanamide type situation, and she referred to the idea that Apple may have wanted to develop a case that other interim relief would be appropriate. Now, I've got 3 points I'd like to make on that. Firstly, the vast majority of the points Apple ran were all about the Economist modelling, and that is why the judge has focused on it in his judgment. There is a passing reference in the transcript to the idea that it could be interim relief, and I'll just give you the reference. That's 910 to 911 of the transcript at supplemental tab 21. I should say I'm giving you the internal transcript page numbers there. But in my submission, it was really not developed at all. And my learned friend may say, well, that's because it was all too late, but I don't accept that. And the reason I challenge that suggestion is because Apple had a pleading, positive pleading, that what was required in this instance was interim relief. And that is something that had been on Apple's pleadings and it chose to drop. And I'll just show you where I get that from. We haven't got all the pleadings in the bundle, but we do have a list of issues which identified that. as a case that Apple was advancing originally. And that's back in Core 19, tab 19. And it's at page 228. So if I can just direct you to paragraph 2D. The defendant's alternative, this is all to be heard, just to show you, this is issues to be determined at trial F, which you see from the title on the page before. The defendant's alternative case as regards interim relief, pleaded at 120 to 122 of the defence. So that point was front and centre of what Apple had said they wanted to run at trial F, and they chose to drop it. Now, it can't be said that was dropped because of some amendment application we did or didn't make. It had been something they had considered and decided not to run. The last point I'd make on the idea of interim relief is that even if they had properly run it, as they say they would have done, in my submission, as a matter of principle, the judge would clearly have rejected it. And the reason I say that is because although they didn't run the point by reference to American cyanamide evidence, they did run the point under discretion that all the court was dealing with was an interim position that could be managed by way of damages. And I showed you that earlier, but I think in light of what was said, I should just show you again. That's paragraph 340 of the judgment at tab 13. The judge specifically said that this is not just a question of an interim position pending a further determination, but a substantive loss of rights for the patentee in respect of an ageing property right. So even if Apple had said, well, really, I know Optis say it's permanent relief in the sense of final relief, but in substance, it's just dealing with an interim position, which is how my learned friend addressed you on it today. In my submission, that would have been given short shrift, and rightly so, because what the judge is identifying there is it's not just a question of some interim position that needs dealing with pending trial. It's dealing with a situation where a patent holder will get a substantive loss of its property right, akin to a compulsory licence in circumstances where they won't be guaranteed to be remunerated. So in my submission, even if they'd argued it, it's not a question of evidence, actually, it's a question of principle in my submission, and it would have been rejected. Now, the next point that Apple makes is that somehow the fact that we'd applied to amend previously and dropped it changes the analysis I've just been through, and it makes what the judge did procedurally unfair. In my submission, that's not right. Apple had run as a backup a middle ground construction, which is where you aren't a beneficiary on day one, but you can become a beneficiary in the future. And on the basis of that, Optis had indicated in its pleading that what would flow from that kind of finding would be a FRAND injunction. Apple said, well, we're not going to run that construction, so we, on that basis, dropped our amendment, and that's what's shown in the recital that you looked at earlier. But that doesn't mean that it wasn't open to the court to say, well, now I've come to that construction, the appropriate and just relief is in fact FRAND relief. And on that point, I emphasise the fact that the court has found that the FRAND injunction concept was built into Apple's own critique of Optis's case. So it absolutely knew the form of the injunction, and it knew the basis upon which it could arise, because they argued that one of the problems with Optis's case was the unqualified nature of the injunctive relief. There's another paragraph of the judgment that I say has an impact on this question of procedural fairness, and that's at paragraph 360 of the judgment. And the judge here is talking about the real strategic dynamic. He says Apple wanted to pen Optis into arguing for something relatively more extreme and open to criticism, and to prevent discussion of the obvious and more moderate approach, which might meet those criticisms. In my submission, that's quite an important finding by the judge, and it's exactly the kind of thing that the judge, steeped in the procedural history of the case, and indeed hearing the evidence in the case, was entitled to make. The point he's getting at is Apple wanted to be in a position to point out that the injunction shouldn't be an unqualified injunction, but that the court should say, well, for a procedural reason, I'm not going to qualify it. I'm just going to make an order that there's no injunction at all. And in my submission, that would not have been procedurally or substantively fair. Now, there are some points in Apple's skeleton that they made about applying to amend. I had some points on the case law, but none of it was gone to in opening. May I just say what my answer to it is, and then if you want me to, I can show you the case law.
Briefly.
The point that Apple made is they said that the court should not come to a decision which was not pleaded in advance by either party on the evidence. But in my submission, the cases they cite are extreme cases where the court had made factual decisions that were not supported by any evidence or pleading. The case here is very different. Construction is ultimately a matter of law, and it's for the court. And no one could suggest the court was hamstrung to pick between Optis's construction in toto and Apple's construction in toto. And in those circumstances, it's perfectly fair and indeed anticipated by the parties the court could come to a middle ground both on construction and on the precise form of injunction to be ordered. Apple also say that Optis should have been required to apply for permission to appeal. So, permission to amend. Apple should have been required to reapply for permission to amend. That's paragraph 75 of their skeleton. But the reason they say that should have happened is they say then they would have had a chance to argue why it would cause prejudice to them or it was too late. But in my submission, all the points they identify in their skeleton are points they were able to make in front of the judge. So even if Optis had had to amend its pleading, the substance of the debate would not have been different. And I can make that good by reference to their skeleton. This is tab 7 of the core bundle. So this is core tab 7, page 62. They identify two things they would have done, they say, had Optis been required to make an amendment application in 75. They say, one, they would have explained that they would have wished to produce further evidence, and two, they would have dealt with their complaints about clarity. Now, in my submission, both of those things were dealt with by the judge. He made it clear on further evidence what his conclusion was, and as I've said, there's no reason to think that he's done anything other than exercise the appropriate assessment of the issue overall. And he's also made it clear that there isn't a lack of clarity because the nature of the Frowned injunction is built into Apple's own arguments. And in that scenario, it can't be said that Apple didn't understand the nature of the issue because they were arguing about it at trial. And finally, on the clarity point as regards the form of the injunction, I think you have this, but although paragraph 5A of our prayer for relief wasn't part of the trial F trial, it showed very clearly what the form of the injunction would have been. And so once the judge was talking about the Frowned injunction, everyone knew at the trial what he meant, and indeed what the parties were talking about. So in my submission, the idea that there should have been an amendment application and that would have resulted in a different analysis by the judge, or that different arguments would have been able to be discussed, is not realistic in light of what you see the judge doing in paragraphs 358 to 360, which is a perfectly appropriate overall assessment on a procedural case management issue. And the court came to the view that, that there was no procedural unfairness. In my submission in that regard, there is no error of principle by the court.
Thank you, Mr. Jamal.
I'm grateful.
Thank you very much. And so I think we've covered all your grounds and the Court appeal.
Yes, my lady.
Thank you. Mr. Mitru. Ladies, my lord, in reply, I'm going to start with the question of jurisdictional balance. The way that Ms. Jamal sought to answer our point was by reference to the Supreme Court's judgment in Unwired Planet. But we say we're not disputing the Supreme Court's finding, of course, in Unwired Planet. So in Unwired Planet, the court decided it was right to set FRAN terms, global FRAN terms, and we don't dispute that. So we don't dispute the court's decision to set FRAN terms or its decision to set global FRAN terms. And the court decided that the sanction for not taking the global FRAN terms that had been set is an injunction, and we don't challenge that either. The court did not say in Unwired Planet that the sanction for not undertaking to take FRAN terms in advance of them being set is an injunction. And the court simply didn't address that issue because the claimant was not seeking such an undertaking in that case. Our point is that the jurisdictional balance set by the court in Unwired Planet is a delicate one because the court is setting global licence terms and to that extent, to some extent, treading on the toes of other courts whose jurisdiction it is to decide the price for use of their patents. However, the Supreme Court found the balance to be appropriately struck because it was the natural consequence of the court's logic of not allowing infringement where there's an actual licence to be taken. So unlicensed use in that situation would unequivocally be caused by the implementer. If it doesn't want the licence, then the Supreme Court reasoned it's perfectly proper to shut the implementer out of the UK alone. Now, in our case, that logic does not apply, and the court this case, the point on this appeal raises a more delicate jurisdictional point than the one in Unwired Planet, because making the implementer sign up to the licence as set by the English court before it's even known is more onerous than the obligation imposed on the implementer in Unwired Planet, because the implementer is exposed to the risk that the licence might be uncommercial for it, even if within the FRAND range. And as I've previously explained, there are two problems that follow from this. The first is that if the implementer signs up, then it risks being stuck operating in the UK when it would have preferred not to be here. This also involves the implementer having had foisted on it global terms that it turns out it didn't actually want. And if that risk is too much, then it must submit to the injunction before FRAN terms are known, even if it turns out that FRAN terms would have been acceptable to it. So in that alternative case, it's shut out of the UK market when it could, it turns out, have stayed. Both of these involve the implementer being forced to take a suboptimal decision to remain or to leave the United Kingdom and to take or decline the global terms set by the English court, when it would have been preferable to take the opposite decision. And being subjected to both of those risks may not be the implementer's fault at all. The situation may have arisen because the SEP owner has never fulfilled its obligations under Huawei and ZTE and Etsy to make an actual FRAND offer. And so applying Optis's rule that the implementer must elect whether it's staying in the jurisdiction without knowing the price for staying in the jurisdiction is, we say, jurisdictional overreach, because in contrast to Unwired Planet, the court is not driven to adopt the rule at all. The court doesn't have to create jeopardy for the implementer as to its decision to remain in the UK at all, or not. It can simply allow the implementer to take its decision once FRAND is known, as indeed the court did in Unwired Planet. And that is, we say, the answer which properly gives effect to Huawei and ZTE and the Etsy Clause 6.1 obligation for all the reasons that we've already given. And I did in opening, and I'm not going to repeat the submissions I made, give the court a series of hypothetical examples to illustrate this, including an example which demonstrates why it's worse for a global operator, why the application of this rule is worse for a global operator than it is for an operator who's only practicing UK SEPs, who, if they commit to the licence, then of course they have to take it. But they do have a practical choice, because they can withdraw their business from the United Kingdom at the end of the day. And that's why we say it's jurisdictional overreach. And my learned friend, with respect, didn't grapple with any of those hypothetical examples. She just made the bold point that Unwired Planet says it's all okay, and we say that that is wrong. I turn next to the relevance of negotiations, which Mr. Miles sought to downplay, but of course the Supreme Court has reinforced the idea that negotiations are important and a premise for the way in which ETSI operates. And my learned friend made a series of points, of submissions, about why the judge's construction of Clause 6.1 does not, contrary to our submissions, allow negotiations to be bypassed. And one of her submissions was that the court can use case management powers to stop or to sanction a SEP owner which is refusing to engage in negotiations. And we say, well, yes, that would presumably include not granting a SEP owner an injunction if they've been obstructive, which is really the point that arises in this case. But really, all of my learned friend's submissions, which were of a general nature, and so she essentially said things like, well, it's usually in SEP owner's interest to negotiate. But with respect, none of those submissions grappled with the assumptions on which the court has to work in this case. And the assumptions are that there has been no negotiation because Optis has obstructed the negotiation. And the construction of Clause 6.1 has to be robust to that scenario. Mr. Mull then sought to address our point at the weight that we place on Apple's own FRAND offer. And she said that Apple's own FRAND offer is not an answer to any of this. She says it's not an answer because she says Apple must take whatever FRAND offer the SEP owner is willing to make, including the licence set by the court. So it's not enough, she said, for an implementer to offer any old FRAND licence, but they must be prepared to take whatever licence the SEP owner offers. And we say that that doesn't help. In fact, it rather reinforces our point that the defence to an injunction which we've raised is still to be determined, because there is no licence on offer now from Optis. And what if the court, when it's determining the FRAND terms of the licence at Trial E, what if it determines FRAND at the same point that Apple offered? So it decides terms which are exactly the same as those FRAND terms which Apple proposed in the negotiation. It can't possibly be said, we say, in those circumstances, that Apple is unwilling, because Apple will have already offered those licence terms. And really what this goes to reinforce is that this is still up for grabs in the litigation. Whose fault is it that there is not a licence at the moment? There are really two questions that fall to be determined in a case like this. First of all, where an injunction is being sought, is the implementer licensed already? That's the first question. Well, answer no, we accept that. Question two, whose fault is that? Now, if it's our fault, then there will be an injunction against us. But we just don't know. And that's really our point. That is yet to be determined, and it is critical. A short point on good faith. My learned friend sought to place weight on the fact that the Supreme Court didn't ask itself whether Huawei was acting in good faith. In fact, I think there was a reference to good faith. But anyway, the point is not an illuminating one, because of course the Supreme Court didn't go through that analysis, because the licence was on the table and Huawei wasn't taking it. The answer was obvious to the point. It wasn't argued, it wasn't a matter that was in dispute. I then turn to paragraph 285 of the judgment and the question of construction. And you'll recall, I think we don't need to turn it up. I think the court, you'll probably have in mind what paragraph 285 says. But Ms. Jamal sought to distinguish between what she called the construction question, which is the first sentence where the judge talks about intending to take a licence, and the application of that construction in the second half of the paragraph. If you do want to see it, it's behind tab 13.
Page 182.
I'm very grateful, my lady. So Mr. Howell's point here was that the first sentence, I'd express the class of beneficiaries as any undertaking which wants a licence to work a relevant standard by any commercial activities and which intends to work the standard under a licence from the SEPA. And she says, well, that's the interpretation of clause 6.1. And what comes afterwards is the application of that interpretation to this set of facts. But if you're saying, well, here's the test, intend to take a licence, and then you say, anyone that doesn't give the commitment, regardless of the facts, because the judge says that's not fact sensitive, is not intending to take a licence, it comes to exactly the same thing.
Well, it's not quite what the judge says. The judge says whether or not this might be fact sensitive in some cases, it is not in the present case.
That's right, my lady. So he says it might be fact sensitive in some cases, but then he's turning to the question in this case, which is the failure to give a commitment. And what he says is that's not fact sensitive.
Right.
It's not fact sensitive. And so if you're saying that the failure to give a commitment, there's no fact sensitive issue here. If you fail to give the court the commitment to take the court determined licence, then you fall foul of the definition. That is the same as reading a hard-edged requirement into the definition. It comes to exactly the same thing. The next point I make relates to the form of holdout. And Ms. Jamal sought to say, by reference to the Supreme Court's judgment, and she referred to passages talking about holdout in general and delay in general. Of course, we accept everything the Supreme Court says, that goes without saying. But the question really for the court is, well, what is the species or the particular holdout mischief that the judge was concerned about here? And we do say, for the reasons I gave in opening, which I won't repeat, that it is confined to this particular period of time, and it is particularly, the species of holdout is the risk that the implementer, after that period of time, will leave the country without taking the licence that's been set. And what we say about that is that if this is a concern in a particular case, so if that is a concern, then there are other ways of addressing the concern which don't require reading clause 6.1 in that specific way that the judge has. I've already referred to the court's case management powers, and I've referred to the possibility of interim relief. But what you can imagine in terms of interim relief, if there had been a debate about that, would be the formulation of some species of interim relief which is specifically targeted to that risk. That might include, for example, financially securing the position of the SEP owner for that period of time. So, for example, hypothetically, the court could say, well, we're very concerned about this period of time, and we're very concerned that Apple might walk away at the end of trial without a licence. I've explained why that isn't a concern in this case, but we're dealing with all cases. So we're very concerned that the implementer might walk away. Well, the court could have said, well, we understand, SEP owner, why you're concerned about your financial exposure during this period. So what we'll require is an undertaking from the implementer that once the licence is set, even if it doesn't take it going forward, it pays you those royalty terms for this period of time that's elapsed that you're concerned about. So that's the kind of point that could have been debated that's an alternative approach to dealing with the risk that doesn't overshoot, we say, that doesn't require a hard-edged requirement in all cases to take the court-determined licence. One further point, just one further illustration on the hard-edged nature of the requirement, where the judge says, well, it's not fact-sensitive where you don't give the commitment. What if you've got an implementer who accepts that they're practising patents that are valid? There is a constructive negotiation with the SEP owner, but the parties just can't quite bridge the gap. And the implementer says, all right, I do 99% of my business in China. I'm going to go to the Chinese courts and seek a declaration, a FRAN declaration there. Again, I think I've made the point already, so I won't repeat myself. We're not saying, it can't be said in those factual circumstances that the implementer is not willing, even if they don't in the separate UK proceedings brought by the SEP owner, give the commitment. I turn now to the cross appeal, unless you have any questions about our case on construction. On the cross appeal, if the judge is right on construction, then we say Optis is obviously wrong on the cross appeal. Because if the touchstone is intent, whether or not a beneficiary wants and intends to take a licence, that is only something that can be determined in the moment. And so it's quite possible that the implementer will change their mind later, and at that point in time they will be intending to take a licence. So we say if the judge is right on construction, they're obviously wrong. We do rely on the first irrevocable in the ETSI undertaking. I know that the court has that point already. And we do say that preventing an implementer from changing its mind runs completely counter to the ETSI objectives. And I think, again, the court put that point to Mr. Mile in argument, so you have our point on that. Mr. Mile said, well, it's prejudicial to the SEP owner because there would still be a FRAND negotiation, I think her point was, and that would be very expensive and unnecessary if we're right on the permanent injunction. But that doesn't follow at all, because it might well be the case that the unwilling on this hypothesis implementer, a licensee, says, well, we're not interested in a FRAND injunction, we just want to come off the market. We don't want to practice these UK patents anymore, and we're not interested in a FRAND determination. In fact, they may stop selling the product altogether. Well, there won't be, in those circumstances, any expense of a negotiation, but it's perfectly permissible for the implementer to change their mind later and decide to re-enter the market, at which point they will be entitled to a FRAND licence. And really, as Lord Justice Arnold, I think, put to my learned friend, the construction that they contend for really is a recipe for hold-up, and Mr. Mile was pretty blatant about that in her submissions. Grounds 2 and 3 of their cross-appeal was rather bemusing, if I may respectfully say so, because it seems to accept the possibility that the permanent injunction isn't permanent after all, but that at some point the implementer can come back and seek a FRAND injunction. And we say, well, if that possibility is accepted, well, then it's quite right that that was reflected in the injunction that the court made. Otherwise, it would be a recipe for complete legal uncertainty. So that's our answer to that. Turning to competition law, my learned friend, Ms. Ford, said that the judge was right in that section of his judgment to say that things have moved on since Mr. Justice Burse's judgment in Unwired Planet because of the Supreme Court. But as she rightly acknowledged, our answer to that is that the Supreme Court, in its injunction analysis, was confronted with a different issue, namely whether withholding an injunction was appropriate where there had been no abuse of a dominant position, it had found as much, and there was a licence that was determined already and available to be taken. Now, my learned friend said, well, that's all right because the judge turned his mind to that point. Well, we agree with that. We agree that the judge acknowledged that point, but we say that he got it wrong. He didn't give it sufficient weight. Starting point, where there has been an abuse, is, as Mr. Justice Burr said, the injunction should normally be withheld. And the question then is would that be disproportionate? The next point my learned friend made is that the risk of competitive harm, that the judge was right to say that the risk of competitive harm has been addressed already or has ceased. But let me deal first with the question of deterrence, because one of the arguments we made was that you might want to find out, or it's relevant to know all the facts at trial, to work out whether an injunction should be withheld as a deterrent measure. And again, my friend said, well, the judge addressed that point, but let's look at where he did address it, which is at paragraph 327 of the judgment. Page 190 of the bundle. He essentially mentioned it in passing, but really focused on the question of facilitation. So I asked Mr. Mitri in the course of argument what the purpose of withholding an injunction would be. Would it just be to seek to deter other SEP owners from behaving in the way that Apple says Optis has? She said it would not just be deterrence, it would be facilitation, endorsing and assisting that policy. And then he rejects that point, but he doesn't really grapple with the point about deterrence. And we say that it is a point that would need to be addressed once all the facts are known. And it's clearly a relevant point that the court should address its mind to when considering, in the light of an abuse, whether or not it's correct or disproportionate to withhold the injunction.
So, can I be clear what you mean by deterrence in making that submission? Because what the judge is there focusing upon is deterrence of other SEP owners. Is that indeed your submission?
We say it's both, so I think he is only focusing on that, but our submission is both, that when a court is, the question whether or not to withhold an injunction is a question of proportionality. The starting point, we say, is that it should be withheld if there's an abuse. And the judge is right to say that it's a multifactorial assessment in which you take all relevant factors into account. And we say that it's relevant both to consider whether or not withholding an injunction in where there's been a serious abuse.
Let's take it in stages.
Yes.
Let's start with Apple. How does the grant or withholding of an injunction now deter Optis's conduct in the past?
Not for the past, my lord, but for the future.
Sorry, what future conduct of Optis are you trying to deter?
Optis's practice in negotiating its practice in negotiating licences, or rather determining.
But you must be talking about other cases. It can't be this case.
I'm talking about other cases.
Right.
Yes, and so the point.
All right. So you are talking about deterrence of Optis vis-a-vis different implementers.
Yes, or Apple in the future.
In a different case.
In a different case.
Behaviour in the market.
Behaviour in the market. So what we're saying, and we say that that's relevant. So if, in fact, for the sake of argument, what's established at Trial E is that this is a policy that Optis has adopted. So say it's adopted a policy saying we think we're going to do rather better in terms of royalties. If we obstruct negotiations, we really bypass them, go straight to the English courts and put the implementer at the election of committing to the licence before it knows its terms. And we think that that's going to put
if
pressure.
what we're talking about is Optis, and we assume in your favour that they have behaved abusively by disrupting negotiations in the past vis-a-vis you, why are they not deterred by a finding at Trial E that that is what they've done, and an award of damages to compensate you for such behaviour?
They may or may not be, but the judge, it's prejudging the question at trial E, because one can imagine, for example, that to take the hypothesis that I've described, let's say that it is a policy that Optis has rolled out to behave in this way, precisely with the purpose of trying to exact higher royalties, indeed suprafrand royalties. Well, the court might think at that stage, well, this is outrageous. Damages are not an adequate remedy for this, because they're quite hard to quantify, because we're now at the stage where a FRAND licence has been set, so it's quite hard to quantify those damages. And Optis needs to be deterred from engaging in this type of behaviour for the future, so we're going to withhold an injunction. Or, as I put it this morning, my lord, it may be that the court decides not to withhold an injunction going forward from Trial E, but that the appropriate sanction is to say, well, no, you're not going to have it from the earlier stage because we want to express our disapproval of your conduct. And we say that that is the type of consideration that the court would want to and would need to, and it would be relevant to take into account once the facts have been found. It's a bit like...
So the other form of deterrence you were relying upon was of third-party SEP owners, so not Optis at all. Now, again, can you enlighten me as to how the grant or withholding of an injunction against Optis in the specific facts of this case deters other SEP owners, third-party SEP owners?
My lord, I hope so. So we say that if Optis has pursued, take my hypothesis, if it has pursued this policy, well, this is the way to go about determining FRAND licences. We think that we're going to get very high royalties if we do it this way, and that comes to light at trial, then it may be that other SEP owners looking at this wouldn't terribly be deterred by an award of damages, which are quite hard to quantify, because it might think, well, we'll never get to damages award. But if an injunction is refused, that's a different matter, because the injunction, of course, is the main weapon that the SEP owner has in enforcing its patents. Now, I'm not telling you that that would definitely be the answer, but what I am saying is that depending on the facts, it would be a relevant matter for the court to consider. Now, the other point we make, apart from deterrence, is that the court...
Just
I'm so sorry.
on that last point,
Yes.
are you able to cite any case in which the court has withheld an injunction pour encourager les autres?
I don't have a case to hand, but we say that it follows, the question that one has to ask is are there any factors, is it a factor which is irrelevant to the question of an injunction? And we say no, because the court has a very wide multifactorial discretion, and so it's not irrelevant.
So you say it would be a proper exercise of the court's discretion to withhold the standard remedy for invasion of a property right of an injunction, because doing so would stop abuse by different parties altogether.
My Lord, it might well be in a competition case, because of course, the starting point, we say, is that where there has been an abuse. So Huawei says if you fail to do these things, or if you act abusively in seeking an injunction, which is of course...
Where is the authority that competition law deprives people of their property rights pour encourager les autres?
My Lord, as I said, I'm unable to point to a specific authority on that now, but if one looks by analogy at domestic law, there are of course ample authorities, and I wouldn't embarrass my Lord by thinking that you wouldn't have these at your fingertips. But there are ample domestic authorities that talk, for example, about injunctions being withheld when the applicant doesn't come with clean hands to the court. So that's something which can be taken into account. Even if you look at it purely in domestic law terms, the court might take the view that Optis's conduct is so offensive that it would be appropriate to withhold the injunction on that for that reason, because they haven't come to the court with clean hands.
But that's a separate point from
It is a separate point. It is a separate point, and I don't have an authority at my fingertips, but I do make the general point that the court has a very wide discretion, and I can't think of an authority where a court says that's not a relevant consideration to take into account. Now, yes, and as Mr. Pickford reminds me, it's really the starting point, of course, is Huawei and ZTE, which is that where an injunction has been sought abusively, then the starting point is that there is a good defence for the injunction. That's the starting point. Now, the other point that we say that the judge, in finding that the abuse had ceased, hasn't addressed, is the detriment that arises from being deprived of a proper negotiation. A negotiation where it actually matters that what is on offer is commercially viable to the operator. Because, of course, in a negotiation, my small implementer who says, well, you're asking for this, but actually I just can't afford it, has that bargaining chip. The small implementer can say, well, look, if you're going to go above X, I'm going to go out of business. I'm not going to take your license, and so you won't get anything. And that will be a bargaining chip, or not even a bargaining chip, but a constraint of the negotiation. And what the judge didn't address in finding that the abuse had ceased is the detriment that arises from that not being a part of the negotiation. Now, Ms. Ford said, well, Apple knows where it stands, and that the judge made a finding of fact that Apple knows where it stands on the pleading. But the provision of a pleading, which parenthetically I say, I've already made the point, has changed dramatically since Trial F, is not a substitute for a genuine negotiation where each side have engaged constructively on the numbers and on the question of quality and strength of the portfolio. It doesn't help, the pleading alone doesn't sufficiently help the implementer to know where the licence FRAN terms are likely to land. Ms. Ford also then went on to address our point about whether or not the judge should have considered our point about an injunction at Trial E. So if we're wrong on injunction, whether nonetheless it would be more appropriate to withhold the injunction at the Trial F stage. And she said that the judge considered that point, and he did very briefly, but our point is not that he didn't consider it, it's that he wasn't equipped to decide it, and that's where he went wrong. I'm going to turn finally to Huawei and ZTE, and I can deal with this quite shortly. So my friend's argument, I think, boiled down to this, that the steps required of the SEP owner, so making a FRAND offer and giving notice and all of those steps, only bite if the implementer is a willing licensee. And she said, Apple's not a willing licensee because it hasn't given the commitment. But with respect to her, that conflates Optis's construction argument with the requirements of Huawei and ZTE. Because the Huawei and ZTE judgment does set out what needs to be done by an implementer in order to be a willing licensee, and Apple has done those things, it must be assumed. Finally, Ms. Ford said, well, if we're right, then any implementer could simply plead a spurious competition case, and there never could be an injunction at the trial F stage, at the interim stage. And we say, well, no, because the way of dealing with injunctions is by interim relief, because that is a method that is sensitive to the fact that the competition argument may win or lose at the end of the day. It's not by reading in a hard-edged requirement to clause 6.1. I'm going to finally turn to ground 4. I want to hand up the pleading. So Ms. Jamal very fairly acknowledged that they weren't running the paragraph 5A point at trial F, but I do just want to show you the pleading so you've got it. It should have been in the bundle, frankly.
So we've got 2 items on the desk. Oh, you've got them.
Do you have the response to the defendant's statement of case on the implications of the defendant's undertaking? I think I can do it shortly by reference.
Yeah, we've got both of those.
Thank you. So let's just do it shortly by reference to that. If you turn over to paragraph 2.
And we're in the response.
We're in the response. And again, this is, I'm grateful to Mr. Jamal, this is not a controversial point, but I do just want to show it to the court. So paragraph 2 sets out Optis's case in relation to the new claims being the claims which are going to be decided at trial F. And then it's paragraph 3 which is important. So paragraph 2, you've probably seen from the judgment that Optis was running various points on timing. So at what point was the commitment required? Was it after a finding of infringement, or they were previously running a case that it was before that finding, which was dismissed, and they don't cross appeal on that. Then 3A, Optis's case is that the commitment should be provided by an implementer, should be unequivocal and not contingent on the facts and matters which are set out in the Apple undertaking. Then we have B, not entitled to avoid injunctive relief absent the provision of such a commitment. Furthermore, Optis's primary case is that at the latest the commitment should be provided by an implementer once the patentee has unequivocally committed to offer the implementer the licence resulting from an appropriate FRAND determination. And then you have the alternative timing point, which is at D, by the time of the first infringement trial, alternatively by the time of the determination of the trial. And then E, Optis's case in respect of each of the alternatives referred to at paragraphs 2, D and E above, is that if Optis is right that Apple has lost the ability to rely on the ETSI undertaking, Apple cannot become a willing licensee and or regain the right to rely on the ETSI undertaking and or avoid an injunction in respect of any patent that has been found to be valid and infringed by giving the commitment only after judgment in Optis' favour on that point. And so the agreed position between us is that they weren't running the 5A point at trial F. Now, in response to our arguments on procedural unfairness, Mr. Jamal took the court to paragraph 358 of the judgment, where the judge found that, he says, so really the notion of a FRAND injunction was embedded in Apple's own arguments. Now, I think what the judge must mean by that, and I have to confess it's not entirely clear to me, is that because we were saying that a permanent injunction was too extreme, in that sense, a less extreme remedy is consistent with our arguments. I think that's what he must have meant. But we say that that doesn't meet our point, and the reason it doesn't meet our point is because different issues arise once the point is confronted, once the fact is confronted, that Optis is not looking to exclude Apple forevermore from enforcing the ETSI undertaking, but is concerned to find protection in the interim period. And once that point is in play, then different considerations apply. Mr. Mao then said, well, we had our chance before the judge to argue about whether we would have adduced further evidence, and we made our arguments and the judge rejected them. But with respect, that's our point. We were taken by surprise by this being raised by the judge on day 4 of the trial, and we didn't have a proper opportunity to reflect and consider and to make submissions on that point. The key point, the key question for the court is there a risk of prejudice? And we say that the judge couldn't have safely reached a view on that because we didn't have a proper opportunity to argue it. Ms. Jamal then said that the interim relief point was mentioned but not developed. Well, again, I make the same point. It came so late that we did think of it, we did mention it, we did say, well, this raises a question of whether interim relief would be more appropriate. But of course we didn't argue it as we would have argued it if we'd had notice of this. And that's really our point about prejudice. Ms. Jamal also relied on paragraph 360 of the judge's judgment, where the judge said, you'll recall, oh, this is all about Apple trying to box Optis in. And with respect, we say that that is speculative. Pleadings have a purpose, and Optis had not pleaded this alternative case and hadn't pursued its amendment application, and we were entitled to proceed on that basis. Our evidence was directed to the case that was pleaded. Optis could have pleaded an alternative case, and it never did. And Mr. Mal says, well, the judge thought it was the obvious approach, but of course Optis hadn't thought it was the obvious approach, or for whatever reason hadn't decided not to plead it. And I ask this, what if the judge hadn't come up with the point? So what if Optis had on day 4, unprompted by the judge, said, oh, well, we now want to argue something different. We've got an alternative case based on a Frowned injunction. Well, they would have had to have applied for permission to amend, and there would have been a proper debate as to whether or not there was prejudice. Now, Ms. Jamal says, well, it wasn't necessary to apply for permission to amend because the judge found it wasn't necessary. But with respect, that doesn't meet our point. The judge might have found that they shouldn't have been granted permission had we had the debate. But that wasn't how it evolved. And we say that that substantively, the mischief at which the alternative case is aimed is a very different proposition to the permanent injunction. And we would have wanted properly to reflect on it and decide what evidence we wanted to adduce and to have decided how to argue it. And you've already seen from my submissions that we think, as a matter of construction, the judge overshot in construing clause 6.1 in the way that he did, and that there are other means of protecting that interim position that would have been more appropriate. Unless the court has anything further, those are my submissions in reply on behalf of Apple.
Thank you very much indeed. I think we're left with a reply in relation to the cross appeal.
Unless I can assist you, I don't have any other points in reply.
Thank you very much indeed. And so I think we have covered all the ground in an extraordinarily short amount of time. May I thank everybody, both those who have been on their feet and those who've done an enormous amount of work in the rows behind for the way in which this case is being presented and the very interesting issues which it raises. We will give judgment immediately because it's all so obvious and so it has been so well presented. No, we will reserve our judgments. Just seeing if you're awake, and they will be handed down in the usual way, and it will be dealt with in the usual way. Now, in relation to that, you'll be perfectly aware, therefore, that consequential submissions, if you cannot agree, we'd be grateful for short submissions on paper, and they will be dealt with in that way. And I also ought to remind you, given recent events, that the draft judgments, when they are sent out, will be subject to an embargo, which will be taken extremely seriously. So thank you very much indeed, all of you, and we have a lot to think about.
All right.